Welcome to Divorcing Strong, the podcast that pulls no punches when it comes to divorce. I'm Becky Sampson, better known as Bulldog Becky Brockovich, and I'm here to give you the straight talk, the strategies, and the subpoena secrets you won't hear anywhere else. With expert guests and proven advice, you'll learn your rights, your options, and gain your power that encourages a fair and equitable outcome. Divorce doesn't have to break you. It can build you. Let's get to it. All right. Welcome again, everybody, to another episode of the Divorcing Strong podcast. I'm Becky Sampson, your host today. And I first have to say, I feel like the luckiest girl ever that I get to not only bring you amazing people on each one of these podcasts, but I get to connect with them. I get to hear their stories. I get to share them. I thank you so much for all of you who have been listening and who have been watching and who have been sharing these episodes with your family and friends who have been through divorce. I mean, I get calls on a daily basis from people going, Becky, please help me. You know, I need resources and be able to help people navigate through this process. So today is it's no exception to amazing people that I'm bringing onto this podcast. So I'm joined by Erin Wilson. She's the founder and principal attorney of the law offices of Erin M. Wilson, LLC, and a Chicago-based firm focused exclusively on family law. So Erin's built a reputation for handling everything from simple, uncontested divorces to the most complex custody and financial disputes with both strength and compassion. What makes Erin truly stand out in her multidimensional approach is she's not only a powerful advocate in court, she's also a mediator, a parent coordinator, and a court-appointed child representative and guardian at Litem. And we're going to talk a little bit about that. But if you don't know what that is, we're going to talk about it. But she's helping families find resolution while protecting their children's best interests. Outside the courtroom, Erin gives back as a mentor through Women's Bar Association of Illinois and is passionate about empowering other women in law. She's also a hands-on mom who understands firsthand the balance between family, career, and emotional resilience. So in today's conversation, we're going to go beyond just the legal mechanics of divorce and custody. We're going to explore what it really takes emotionally and strategically to come out of this season stronger. Whether you're navigating a contested case or preparing for an uncontested path, Erin offers insights that can help you understand your rights and your options. So I want to go ahead and welcome Erin to the stage or to the show.
Hi, thanks for having me.
Oh, it's so great. It's great to have you. And I appreciate you taking the time out of your very, very busy schedule. I always say that with the divorce attorneys, man, you guys have got, you've got a lot on your plate. So welcome. I'd love to start off the podcast usually with asking, where did you come from? How did you get into being in the divorce space or even the family law? Because there's a lot of aspects to that. And what makes you passionate about the work that you're doing now?
Yeah, thanks for asking. So I wanted to work with kids that had been through a divorce or going through a divorce and really focusing on the children's aspect of it. So originally I thought I wanted to be a psychologist and, do custody evaluations. And it's still, as a psychology major in college, and my practice overlaps so much with therapists as it is. But ultimately, the more I learned when I was younger, going through law school and becoming a guardian ad litem, a child representative, becoming an advocate in the legal field, I felt like I could make more of a difference for families. Yeah. So I went the law school route rather than the psychology route. And so, that's where I landed up after law school. I worked exclusively in family law. So I was really lucky. I knew what I wanted to do and I did. So I'm super fortunate.
Yeah. And so you probably started did you start with another firm and then branch out and do your own firm?
Yeah. So when I worked all through law school as a law clerk in family law, and through those networks and connections, I ended up working for solo practitioner as an associate attorney, and I was there for 10 years. I became a partner at the firm. I really helped grow that practice. I learned so much, a lot of trial skills. My boss was also a guardian ad litem child rep. So it's in Cook County, it's one list and you get appointed as a child rep or a guardian ad litem. We could talk about that later. But so I was there for 10 years and then I opened my practice in January of 19.
Wow. Okay. So, and you have how many attorneys that you work now?
So I have 2 partners at my firm now, and we have 3 associate attorneys. We have an office manager and 2 law clerks.
Oh, wow. And then I know that it's a lot of work to also manage other attorneys and different cases and stuff. So tell everybody kind of what, in your experience, and especially with the 10 years that began and then before you branched out, like what did you commonly see were major mistakes that people made or frustrations that they had during a divorce?
I think it's the other people in their ears, right? Like you want to hire an attorney that you trust and that you can talk to, you're comfortable. Really, trust is the big one, right? And so you can rely on your attorney's advice. And sometimes your attorney may bring in a team, right? We may work with a therapist, a coach, a financial planner, whatever it is, but like one cohesive team that you're working together. And when you start talking to other people not part of the team, or you're looking online, or you're going in Facebook groups, and you have other people in your ear that don't know the nuances of your case, that's, I think, where the challenges come into play, because people who don't know what's specifically happening in your case are giving you advice that's maybe not so sound or solid or helpful. I think that's the challenge.
Yeah, definitely. I think one of the things you just said is trusting your attorney. How do you think that the question that just came to my mind is how do you know when to trust them, or how do you build that trust with them to know enough that you can hire them?
So, obviously I think you should definitely consult with an attorney. You may have people that you do trust that have gone through the experience and say, okay,
right,
this one person is awesome, go hire them, right? Or you're going to get a few names. If someone comes to me for a referral, I'm always going to give 3 names. I tell people, interview a couple people if you'd like. Only hire someone that practices family law, right? Don't hire someone that's going to do your real estate closing and your cousin's DUI and your aunt's will, right? Like,
I totally agree with you, by the way.
Having someone in family law, right? Like, as a family law attorney, you have to know a little bit about a lot of areas of law.
Yeah.
That being said, I know family law, right? I know a little bit about other areas because that's what my clients need. I also have a lot of great trusted referrals too. Hire someone in family law. Once you hire that person, right? Like, you have to hire someone that you do trust, that you're going to tell your secrets to, and that, you trust to give solid advice. The other big piece is I tell people, I'm not a yes person. I'm not going to tell you what you want to hear. I'm going to tell you what advice you need to hear. And you might not always like what I have to say. I'm going to give you the advice. And ultimately, it's your decision, right? What you want to do. You want to take path A, path B, path C. I could tell you this is what I would do. This is what I advise, but it's your decision. I'm also just not going to like green light everything you want to do. And again, client's decision. But I'm not just going to go along because they want me to. I'm going to use my experience, my expertise to give advice, and not to just, some attorneys will literally do whatever their clients want. And that's not us. We really are more, counselors, right? It's counselors and advocates, right, giving advice. And we take that really seriously.
Well, and I would figure that every single case is different, right? So there's a different strategy and there's a different understanding. And so it is very, very important. We do talk about this a lot, that you do the due diligence to research and not just take the first attorney. I say you don't marry the first divorce attorney you meet, because everybody has got different strategies. And it's just like with any relationship, you've got to know that you can be able to work and trust your attorney for making the best doing the best job that they can for you. So one of my questions is, when somebody starts to work with you with the divorce, what's the first thing that you really focus on, and what surprises you most about that? What would surprise them most about that process?
Well, I think I don't know what would surprise them. I'm not sure. I have to think about that. The first step, though, if there's kids involved, I really like to prepare a parenting agreement at the outset. And sometimes people are like, we're not there, we don't even have an agreement yet. But from my perspective, I think clients come in scared, overwhelmed, confused, nervous, unsure, uncertain, especially when it comes to kids. And so I think when they see the details of a parenting agreement, because a parenting agreement contains how you make decisions, parenting time, and then the rules of the road, right? Your right to first refusal, travel guidelines, social media guidelines, communication guidelines. There's so many nuances and details. And a lot of times clients will say, and I care about this and this and this. And it's just so piecemeal that I think giving them a parenting agreement at the start really calms things down. So they can really start to think about what is important to them. What do they want? What questions do they have? Also, then I like to float that out early on in a case so that we can see, is parenting going to be an issue or not? So that's for me, one of the first steps is focusing on the parenting so that you sort of can calm a client down, give them advice and direction, and see where things are going. So that's on the parenting side. Also, we'll do financial affidavits on the earlier side as well.
Explain to people what that is a financial affidavit.
So, and I don't know if it's an Illinois thing, I'm sure other states have financial affidavits as well. It's probably like a 12-page form that's going to make your eyes crossed. Out. It's just at first glance, it's very overwhelming, right? It wants to know about your income, your expenses, your debt, and your assets. And it's it's broken down very specifically. And that really frames the financial side of the case. It's the guidepost. And it's really, I call it your ticket to the courthouse. Excuse me. You can't ask for anything financial. You can't ask for discovery. You can't ask for support. You can't do anything without that financial affidavit.
And so I know that you deal with contested. Well, I mean, what happens if you have somebody that's not willing to give that information?
It's required. It's a required form. So it's, if you have to go to court to compel it, you can, right? You can compel it in court. You can file motions to compel. A lot of times courts will enter orders towards the start of the case. Everyone has 28 days to prepare your financial affidavit. We like to prepare them on the earlier end. So we're usually not even on our end facing court orders compelling this because we voluntarily just do it. But there's definitely paths in litigation to get cooperation if someone doesn't want to play easily. But for us, it really frames the case and it gives us a lot of information. So we try and do this on the front end.
So what happens? So here's a question. So what happens if that other person, they comply, they do their affidavit, but as a spouse that they're not giving you the right information, even though it's under oath, right? It's under penalty of perjury that they're actually putting that financial, but for sure that is not correct. What do you suggest people do?
So much. There's so much that can be done. Like we could do a podcast just on financial affidavits.
People don't realize this is the reason why I do subpoenas, right? Like, so I support attorneys in doing their subpoenas. However, yes, that is a case that it happens all the time. So I'm grateful that this is kind of coming up because people don't know that they have rights, that they don't. So what are the rights around that? If you're like, no, that is not true. He's not spending $12,000 a month. You know what I mean? You
have to think about everything that goes into a financial affidavit, right? Because we talked about there's income. So you can lie about your income. There's assets. You can lie about your assets. You can lie about your debt. You can lie about your expenses, right? And so how you approach when someone lies is really dependent on what kind of bucket we're talking about and what's at issue. So I'll give you a couple examples. Number one, subpoenas, just to your point, right? Like someone puts on their asset sheet that they have whatever it is in bank accounts or retirement accounts or whatever. You're like, that's just not true. Issue subpoenas to the bank accounts. You can issue formal discovery too, like notices to produce, interrogatories, and get the documents. And then again, see what comes back. Watch them lie again. Watch them not produce again. And then issue your subpoenas.
Yep.
or just straight go to the subpoenas. Like, I think, Becky, you and I agree, I think subpoenas are super helpful. And
Yes.
most of the time we issue formal discovery before the subpoena route, but not always. Like,
well, and I think that wouldn't you agree that the courts kind of like to see that you're asking first for it before you would go for a subpoena? Because it just kind of, it's more of an aggressive move,
I would say primarily, I practice primarily in Cook County, Illinois.
Yeah.
And I don't think courts necessarily mind if someone just wants to issue their subpoena. Okay. I think that courts are pretty deferential to how an attorney chooses to do discovery as long as they're complying with the rules.
Yeah.
I think it's much more common to issue your 214, your notice to produce
Right.
first. It's definitely more common. But if someone chooses to go the subpoena route first, that's okay.
Well, that's good news to hear, because I think in a divorce, how important is it that you have all the correct information, and how often do people not provide that?
I mean, two totally different questions.
I
How
know.
important vary, how often, it kind of, not always. It depends on the case, it depends on the dynamics. It depends on the families, right? It's really, there's no one size fits all, and every family dynamic is different. We tell people it's all on paper. We're gonna find it. Obviously cash cases are more difficult, but with the cash cases, that makes the financial affidavit even more important, because when you've got someone saying, their rent or their mortgage is this much, all their expenses is this, but their income is not supportive of it, right?
Exactly.
That's how you prove your cash case is the necessity of there being cash, because you've got no debt listed, right?
Mm-hmm.
So there's no debt. You got all these expenses, but you're only making this. Like, come on now. And so that's, that's where you prove those cash cases.
Yeah, no, it's just an interesting thing, because a lot of people come to me and go, well, Becky, I don't even have any clue where to look for it. You know what I mean? I may not have the account numbers and things like that. I'm like, well, just because they're trying to hide things does not mean that they're hidden. So you just have to know where to look and to be able to, and by the way, I only know this because of what I went through, and wanting a fair and equitable division. And I do appreciate attorneys that do see the value in that, and saying, look, let's just get all the information out on the table so that we can help you navigate, a fair and equitable, not don't gouge them, don't go after them. You know what I mean? That's never the energy that I personally like to be in. It's just, I want people to advocate for themselves. And with you being such an advocate, not only for the children and for the spouse, whether it's the male or female, the husband or the wife, advocacy is just a really important part during a divorce. And many people just don't know what they don't know. So, So kind of going back to the financial affidavit, what other information is on there to really be aware of when you're putting that together for a client?
I mean, it's a very detailed form. And once we fill it out, especially when we get the other sides, then it's a question of, was there transparency during the marriage? When you get that affidavit, do you see it? It makes sense. Yep, these are the accounts. Like, let's get it on a balance sheet. Let's really start dividing it. Or do you know there's accounts missing? Are there accounts that you knew existed but you didn't have access to? Right. That really sets the stage for what requests we need to make. And I, like, to your point earlier, that every case is different. I'm not the kind of attorney that at the start of the case is going to issue a notice to produce right away. Right. I want to see what's out there and where the questions are. If you've had a fully transparent marriage, and it's just a function of dividing it, well, you may not need all the account documents exchanged, right? And so we're not going to make those broad requests. I don't need to spend my client's money. Right. That's wasteful. If someone is unaware, if there's concerns about hidden assets, that's when you're making the requests. And, you can find money, right? Like, start from the pay stub. Where is the pay stub being deposited? There's on most pay stubs, it'll give you the accounts where the direct deposit is. Do we have those? Let's look at those statements. Are there transfers, right? And so it's just following the paper trails to where you need to go if you're talking about a lack of disclosure. But again, we're only making those requests and doing that digging when it's necessary.
Right. Yeah. And what that kind of comes to is we did a show a couple weeks ago. I don't know if you know Krista Shelton. Oh my gosh, she works for the IRS. she's like, you can't hide anything. She used to work for them and now she does forensics for people. So, and she has a whole thing of like, what are the red flags, right? And I'd like that you say that you don't just jump in to going into discovery because you may not need it. And you really don't want to create more of an issue in your divorce than needs to be. So I appreciate that you kind of pause there and be like, hey, let's strategically look at this. But yeah, I was going to say any red flags that you see that if people are like, okay, yeah, that's in my relationship that I need to be aware of or
and
or
that
not.
just comes from the trust factor, right? Like we talked about earlier, hiring someone you trust, hire someone that you can be candid with. And, I want to counsel my clients that they feel, and the same in mediation too, right? So I do a lot of mediation cases, and I'm the same way in mediation. I want to sit and go through the balance sheet and ask them, like, do you have questions about these accounts? What do we need to produce? Are you familiar? Are you not familiar? So it's making sure that at the end of the day, like, this is their life. This is their joint assets being separated. And I don't want someone to feel to work through a marital settlement agreement, or even, if you have to go to trial and have these questions of, I wasn't sure about these accounts. And that's really what the goal is. You want someone to feel like they understand the financial side of the marital estate and the non-marital estates too, right? So segregating marital and non-marital, they need to feel like they understand everything so that they can enter into agreements that feel comfortable and you're not questioning it afterwards.
Yeah. So you just brought up an important part because most people don't know what that means. What can you explain to them what a marital asset would be versus a non-marital asset? Because people, especially if you're not the main person that's in the whole financials of a divorce or even in a marriage, you may not know what that means.
Sure. Yeah. So, and I'm speaking from Illinois law, right? So, but I'm sure it's pretty similar across jurisdictions. Anything earned during the marriage is presumed to be marital, except there are exceptions. So you have exceptions of during the marriage, and then what you came into the marriage with is non-marital. It gets super nuanced. Like, for example, let's say we have a 401k, a retirement account, and husband, has been working at a job since 2015. They get married in 2018, divorced in 2025, right? There's going to be a portion of that account that has non-marital money, and then the remainder is marital money. And so there's certain ways as attorneys or financial analysts that we can do calculations that segregate the non-marital portion from the marital portion that is subject to division. That's just one example. Other ways you could be talking about non-marital money, inheritances. Yes. I mean, those are the two big ones that come to the top of my head right now. And just anything that you came into the marriage that's remained segregated. Again, not to get super complicated, you can transmute assets from non-marital to marital money. I mean, there's a lot of nuances of what, and this comes into play a lot with homes. When someone owned a home before a marriage and then maybe refinanced it during the marriage and then added that spouse during the refinance process. So it gets super nuanced and super complicated, but generally speaking, money and property earned and acquired during the marriage is marital, except if it falls into a bucket of exceptions, such as gifts and inheritances.
Yes. And in every jurisdiction is done differently. So like she's saying, like in Illinois, it's one way where it could be in your state. And I always recommend when people come, I mean, obviously I'm not an attorney. I just put them to the statute in that particular state and have them go research. Yeah. And people don't realize that you can do that. Every single state has the statutes, which is how the attorneys and the judges abide by, right, on how your jurisdiction deals with that. Because people.
Sorry.
No, go ahead.
I was going to say, like on our website, for example, we have a lot of articles and information. So not all attorneys do, but there are some attorneys. Like, so, become as educated as possible, right? Like just become
Absolutely.
super educated and, you know, work not only with your attorney, but if there are other trusted members of the team as well, that can help you, you know, flesh through all of this.
Yeah. Again, another reason why it's important to get really solid information, because you want to make information, or you want to make decisions on that information that is legit. Because
sure.
that goes actually back to what you first started this whole thing with, is that people are listening to a lot of different voices in divorce, and it may be friends that have good intentions, or maybe people that have been through another divorce, and so they're saying, hey, this is the way it is. I'm like, well, every situation is different. Every different situation. So here's another question I'd like to just kind of, I know we kind of touched on it before, is about guardian ad litems, and people don't realize what a guardian ad litem is and what is their role in a divorce, and especially if you've got some really high conflict issues to deal with. You know, answer that.
Yeah, and I'm so glad we got back to. I know we've bounced. Yeah. As it happens. And so I'm glad we got back to this. This is really, I will say, guardian ad litem child rep work is what I love. This is really why I got into family law. You know, the money stuff is the money stuff, and we're good at it. And I'll tell you, my partner, especially, that's her favorite. I really like talking about the kid issues. That's where my passion is.
Yep.
And okay, so what is a guardian ad litem? First of all, let's just frame that there's one list of attorneys, and you could be appointed as either a child representative or a guardian ad litem.
Okay, so what's the difference with that?
Yeah, so the main differences are a guardian ad litem is the court's witness. You are the eyes and the ears of the court. At a trial, you are the court's witness. You write a report. You are subject to cross-examination. You're subject to subpoena, actually. I can be subpoenaed as a guardian ad litem.
Interesting. I didn't know this.
Yeah.
Okay.
So
that actually, yes, go ahead.
So I can sit for a deposition, or I can have my file subpoenaed.
Yes.
So there's nothing confidential as a guardian ad litem. Nothing. Okay. So let's contrast that with a child representative. A child representative is someone who acts as an advocate at a hearing or a trial. So you argue as an attorney, you can question witnesses, you argue based on the evidence. Versus a guardian, you are the evidence, right?
Yeah.
You are part of that trial, and people question you. As a child representative, I can question. There is, and the other big difference is confidentiality exists between the child representative and the child, not the parents. The parents never have confidentiality, but between the child and the child representative, there is confidentiality.
Which means that you can't, so you can't do a deposition with
the child representative. No, I'm not subject to I'm not subject to subpoena. I act as an attorney. Now, practically speaking, during majority of the case, whether you're a child rep or a GAL, you're doing most of the same things. You're doing your investigation. You're meeting with the kids. You're meeting with the parents. You're meeting with the collaterals. And frankly, you're focused on resolution.
Right.
You really are trying to bring about a fair resolution that prioritizes the best interests of the children. And, you know, people ask, like, well, when do you appoint a GAL versus a child rep? And again, speaking just from Illinois and especially Cook County, a lot of it is dependent on age. When you have sort of, you know, older adolescent teenagers, you may be looking more at a child representative because of that confidentiality aspect of it. When you know, guardians can sometimes be more helpful. If you know a case is on that trial trajectory and you want someone who can testify, that's where you may want a guardian. Also with little kids, you're probably always getting a guardian ad litem because the confidentiality piece just isn't as important. Those are the main differences. But again, really similar functions in advocating for children's best interests, protecting children's best interests.
So what do you suggest people do, though, if you feel like your child is not being protected, or the guardian ad litem is not putting the child's best interest at, you know, up front? Like, what would you suggest somebody does?
So obviously, it's very case specific and person specific, judge specific too, right? You have to kind of know your judges and who they're appointing and what they may do. But listen, if you have to, and I've done this before, I've done it. You file a motion to remove that attorney, and you better be able to back up why you're doing
Why?
it, right? Did they just not do their job? What do you feel they didn't do? Or, sometimes like I've seen it where guardian ad litems misreport what collaterals tell them, right? These are hard situations. We encounter them. We encounter it. And you really need to, trust your attorney's advice, because I think that a lot of times parents don't appreciate what a JL or a child rep may come back with, but it doesn't mean it was wrong. It's just, so it's a hard situation because you're dealing with very difficult, complicated custody situations.
Right.
And, sometimes you're dealing with personality disorders, mental health issues of different parents. And so these are the hard cases. They're the really hard cases. So there are options, right? If your GAL, if your child rep is really not doing what they need, other options that are a little bit easier. One in particular is ask for a custody evaluation. Ask for a forensic custody evaluator to be appointed. If you disagree with the recommendations of your GAL, get what we, in Illinois, we call them a 604. It's because under the statute, it's 604-10B is the court's expert, or C, you can ask for your own expert. You can get your own custody evaluation expert appointed. It's not an automatic. It's within the court's discretion, but it's a really great option. And that's one that the courts really listen to. Like in terms of when you're asking for that, it's sort of an easy answer. Listen, it's expensive. You have to be able to.
I was just going to ask you that. I was like, is it expensive for people to do that?
Expensive.
Because I know several cases right now where it just does not seem right, where these kids are not being protected. And so that's the reason why I asked that, is because I'm like, okay, what rights do they have? Where can they go? Who can they?
Yeah. I would say here's the three things I would say. Ask for your custody expert if you can afford that, whether it's the court's expert or your own independent expert. You can ask for them to be removed. That's probably the hardest. That's probably the most challenging. But also sometimes just filing that motion and putting in your allegations, if they're really, really well grounded, puts everyone on notice. Sometimes it's enough to kind of shake things up. And then the third option is, if you have a child representative, ask for a GAL to be appointed. If you have a GAL, ask for a child rep to be appointed. There's nothing in the statute that prohibits having two of these attorneys in your case. And sometimes, it's very rare, but sometimes it can happen, right? If you have a GAL involved and the child really doesn't feel heard, listened to, advocated for, ask for a child rep to be appointed. They serve different roles. And so that's another sort of creative approach you can take. But again, any of the times you're filing these motions, you're putting everyone on notice. And sometimes the problem fixes itself too.
Well, and that's what I'm saying is that's how I feel about subpoenas too. Sometimes subpoenas is not necessarily the information you get. It's putting them on notice. Like, look, you probably don't want to go down this road. And so they're different tactics that way.
I agree. And the other part I wanted to bring up, sorry, I forgot this other, is if you have a guardian ad litem, you can cross-examine them. So that's another aspect of ways you could point out, is through cross-examination of the guardian. So sorry, I wanted to add that.
No, I love that, because first of all, I'm going to go back and re-listen to this one, because I just have a case that I'm dealing with right now, is because kids are that they sometimes get forgotten in the court systems, and they don't have a whole lot of power. I was going to ask you one other question, is how young can a child be in order to go and testify in court or make a choice of where they live?
So in Illinois, there's no magic age. I know there's I think that's like urban myths, like 12, 14, 16. Those are kind of the biggest urban myths, I would say. So we don't have an age. The child's preference, whether for decision-making or for parenting time, is one factor of the statute, right? So there's a list of factors that the court is to consider, and that child rep or GALs and custody evaluators. We're all bound by the same statute.
Right.
We're all bound by the factors. The child's preference is one of those factors, and how much that comes into play is really dependent on the age of the child, the maturity of the child, right? So you can have a really mature, articulate 9-year-old who can tell their guardian what they want and why, or you can have a 16-year-old who says, I want to go to this parent because I can play video games all day.
Exactly.
So there's no magic age, and it's really a function of the whys. And that's why the investigation is so important.
Yeah. I appreciate the fact that, I mean, your passion is for kids, because we need more advocates. We need more people out there that are really speaking for them and protecting them and going to bat for them, because I've seen a lot of cases where these kids don't feel like they have a choice. They don't have a choice. They don't have a voice. And I actually many years ago was actually asked to be an advocate, even though I've never had children. And just, I'm one of those people that since I was very young, I like to help the underdog. It's like, oh, so this happened. Okay, let's see what we can do. And that's probably one of the main reasons why I started this podcast, is because I wanted to be able to get information out to people and get them connected to resources and people like yourself that will help advocate for them. So I really, really appreciate that. And I appreciate, gosh, we could just keep talking, because
yeah, I know. Even like we started to talk about like courts interviewing kids, and it's like that's a whole nother topic of like,
I know. I was just thinking I probably should bring you back on and just talk all about like co-parenting. How do the kids, like we did a show yesterday. So I grew up at a summer camp for kids, and I interviewed a lady yesterday that's all about youth and empowering them to be leaders. And even during a divorce, being able to, how do you still allow your children to have a voice and to be heard and to be felt and to be seen? And so I guess it's on my radar today as I'm thinking about that. And with that being your specialty, or one of your specialties, it's just like, yeah, this is definitely an important topic, and we definitely could do another podcast just specifically on this. So it's kind of my last question to you, and I've decided to end my podcast this way, is what does divorcing strong look like, or what does it mean to you?
That's a good question. What is divorcing strong? I think, so many times people are so scared, like, their life is changing so differently. And I see so many of the times people just come out on the other side stronger, more empowered, freer, happier. More likely than not, you were not happy in your marriage. Maybe you were like, just kind of going about to get through whatever it is. And I think that people are scared for different reasons to get divorced, financially, because of the kids, etc. But I can just tell you, from my experience, it works out. Like people are happier on the other side. So I think it's just learning that you can be happier in a different family situation.
Oh, I love that. I agree too. I always tell people I'm happily married, but I had no idea that was going to be my future as I was going through it. So I always like to bring hope to people that are going through a very difficult time, that this is temporary, not permanent.
For sure. So it's a hard process. I'm never going to say it's easy. I will try and make it as painless as possible, but it's stressful. It is, right? It's a major life event. And, we're going to do our best to try and get you through this and get you, a good result.
Yeah, absolutely. Well, thank you so much for being on the podcast, being willing to take time out of your busy day. And right there at the bottom is where you can get a free consultation with Erin. And thank you again so much for coming. So
Thanks
hold on
for
one
having
second.
me.
Yes. Well, thank you guys for coming to another podcast, for another episode, I should say, of the Divorcing Strong podcast. I am Becky Sampson. I've been your host. And just as a reminder, I kind of keep forgetting to tell people this, but right here is the QR code that if I truly believe the more you understand about the legal system, the legal jargon, the legal terms, this right here is 100 divorce legal terms that you can study and learn about what your rights are. So make sure you go to that website and you can download it for free, give it and share it with whoever you'd like. Also, make sure to like and share these episodes with friends and family that they're going through divorce, so that they can be empowered while they are navigating this legal process. So thanks you guys for joining us, and we'll see you on the next one. Thanks for listening to the Divorcing Strong podcast. This episode is sponsored by Only Subpoenas, where we make subpoenas simple, powerful, and 100% compliant. If you're having a hard time getting the information you need to settle for a fair and equitable divorce, let us help you. Whether you're an attorney or you're navigating divorce on your own, subpoenas can uncover the truth, secure the evidence you need, and level the playing field. To see how we can help, book an appointment by visiting our website at onlysubpoenas.com.